the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated.
Welcome, everyone. The court will now hear argument in the case of Brian Lochte, petitioner, versus Michael Franklin, respondent. Counsel ready to proceed? Counsel for petitioners.
Petitioner appears by Whitney, Novak and Barclay.
Okay. Respondent.
Aubrey Wilson and Adrien Piercy for respondent Michael Franklin.
Okay. We were ready for petitioners.
May it please the court. Your Honors, we'd like to reserve 2 minutes for rebuttal, please. My name is Whitney Novak, and I represent the petitioner, Officer Brian Lochte. Today, I will explain why Officer Lochte did not violate Mr. Franklin's First Amendment rights, and my co-counsel, David Barclay, will explain why Officer Lochte did not violate Mr. Franklin's Fourth Amendment rights. On September 28, 2011, Officer Brian Lochte performed an arrest under the city's wiretapping statutes. Officer Brian Lochte is entitled to qualified immunity regarding this arrest for 3 reasons. First, Officer Lochte had probable cause to arrest Mr. Franklin under the wiretap statute. Second, the wiretap statute is a reasonable time, place, and manner regulation. And third, even if this court finds there was a violation of Mr. Franklin's First Amendment rights, Officer Lochte is entitled to qualified immunity because the law was not clearly established at the time of the arrest.
Counsel, before you get very far down the road, address the Glick case in the First Circuit. I think it's a killer too.
Certainly, Your Honor. In the Glick case, there was an individual who was in Boston Common. He noticed police officers arresting an individual using excessive force and was plainly videotaping the police officers doing so. He was arrested under Massachusetts wiretap statute, which requires, much like the statute in the city of New London, that there is it prohibits the recording without the consent when the recording is done in secret. And the First Circuit decided that there was not probable cause to arrest Mr. Glick under that statute because it was not in secret. He was doing so clearly and plainly. In this case, that is not the situation. Instead, Officer Phelps, who was being recorded, was not aware he was being recorded. And the statute does say that secret oral interceptions are prohibited. So in this case, there was probable cause to arrest him under that statute. And further, that was, although similarly to this case, it was in a public park, Hyde Park, where in that case it was in Boston Common. Here, that was just an individual viewing some officers performing an arrest. And in this case, there was a protest. This case is more analogous to the Third Circuit's decision in Kelly versus Borough of Carlisle, where the Third Circuit determined there was not an established right to record in an inherently dangerous situation. In that situation, it was a traffic stop. In this situation, it was a protest.
Why is this situation inherently dangerous?
Your Honor, a protest, by its nature, is a large group of people who are gathered, who are very passionate, who are very angry about an issue. It's unpredictable.
By its nature, it's basic Americana to get in the central First Amendment.
Certainly, Your Honor, and Officer Lochte respected the First Amendment in that there were no arrests made for 4 weeks. As he was patrolling this protest, he respects the right to freedom of speech, to freedom of assembly. But in this case...
Particularly by his fellow officer during the coverage.
Yes, Your Honor. And besides the fact that the nature of a protest is unpredictable, there was evidence in the record that this particular protest was intensifying, that protests under the same umbrella in other cities had become violent, and further, Officer Phelps was acting as a leader within this movement. And
So why was it inherently dangerous?
He was keeping the protest safe. He was acting as a bridge in between the police officers and the protest and containing it. And also, by revealing his identity, he was a leader within the movement.
Well, what evidence is there in our record on a summary judgment motion that they were going to reveal that he was an undercover agent?
Your Honor, Mr. Franklin was videotaping Mr. Phelps speaking to the police officers. And he, in the record, it states that he had thought that this was the case, that he was an undercover police officer. He took a video of that, and then he was about to post it on the protest website.
I thought his statements were fairly ambiguous as to whether the man was a police officer or not.
I believe his statements, Your Honor, were he is one of you, and the videotape itself said, why is he so chummy with the NLPD?
Well, doesn't he say that he is one of you after he's been confronted? Mr. Phelps, or Officer Phelps, had been videotaped evidently throughout the entire week. Isn't that accurate?
Yes, Your Honor, and Mr. Franklin had every right to videotape him while he was acting as a leader of the protest, making public speeches. In this case, Mr. Franklin was violating the city's wiretap statute.
By talking to a police officer.
Mr. Franklin was recording Mr. Phelps having a private conversation, and this court has said in its decision in Katz that there is a reasonable expectation of privacy even in public. And
even when you're the leader of a group like this?
Yes, Your Honor, he did not have, while he had consent, or implied consent to videotape him while he was acting as a leader, giving public speeches. In this situation, he was having a private conversation. And just because you are a public speaker doesn't mean you don't have some expectations of privacy. The Seventh Circuit, in a recent decision which dealt with a similar situation, a wiretapping statute, the validity of a wiretapping statute, they even recognized that, yes, that in some cases the Constitution protects conversational privacy, and in some cases private conversations in public are certainly protected. And that goes to my second point of...
Well, going back to this thing, you were saying the Kelly case was relevant because we had an inherently dangerous situation. And I still didn't get an answer to my question of why this was inherently dangerous. Why couldn't your officer, the one who was disclosed, simply escort Mr. Undercover Officer out of the park?
He certainly could have, Your Honor.
Wouldn't that eliminate any safety issue?
Yes, and...
Wouldn't that be a better idea than trampling on First Amendment rights?
Your Honor, he certainly could have removed him. Under reasonable time, place, and manner regulations, the least restricted means doesn't have to be used. And also, it wasn't just officer safety that was at issue, it was the safety of the entire city of New London. And Officer Lochte acted reasonably in his professional judgment. He was a 15-year veteran of the police department. He was a Marine. He felt that this particular situation, he had been patrolling the protest for 4 weeks and never once felt that there was a dangerous situation. And in this circumstance, he did. And further, he did, again, arrest him under probable cause of violating this statute. And this statute is a reasonable time, place, and manner regulation. A time, place, and manner regulation is reasonable when it is content neutral, when it is narrowly tailored to achieve a compelling government interest.
Well, counsel, I asked you about the Blitt case, and you're probably aware there's a sentence in the Blitt case that says, and I'll quote it, that private individuals have a constitutionally protected right to video police carrying out their duties. Unquote. So, my goodness, if that's the case, then your wiretap statute's unconstitutional to the extent that it violates that standard I just gave you.
Your Honor, the validity of the statute on its face is not an issue today. But
that's what you were using as most of your argument. This was pursuant to wiretap statute, resolve probable cause, etc.
Correct, because let me give you an example. In the ACLU v. Alvarez case out of the 7th Circuit, the Illinois wiretap statute prohibits all recording of individuals and doesn't have that secrecy element. It says you could videotape anyone giving a public speech in public, and so long as there wasn't consent, they would be able to arrest you. And in this case, the City of New London's wiretap statute is narrowly tailored because it only prohibits the secret recording. And the compelling interest here is, under the statute, is privacy. And certainly this statute is narrowly tailored to achieve that. Now, Your Honors, even if you do find that there was a First Amendment violation here, Officer Lochte should not be held personally liable because he is entitled to qualified immunity. The doctrine of qualified immunity, the purpose of it is to allow police officers to act, to exercise professional judgment without worrying about violating rights, so long as they're making a reasonable mistake. This court has stated that the doctrine of qualified immunity protects government officials, all but the plainly incompetent and those who are knowingly violating the law. And it is unreasonable to say that Officer Lochte was either plainly incompetent or knowingly violating the law. He was just exercising his professional judgment in keeping this protest in the City of New London safe. The law regarding videotaping of police has not been clearly established. There is indeed a circuit split, and while a circuit split is not enough for qualified immunity purposes, it's certainly good evidence. The 4th Circuit and the 3rd Circuit both have said this is not a well-established right, and also in Glick, they denied qualified immunity to the officer because he did not have probable cause to arrest under the wiretap statute.
Counsel, is anyone else with the First Circuit in Glick? Any other circuit sided with them?
Yes, Your Honor. The 11th Circuit in the City of Cumming and the 9th Circuit in Fordyce versus City of Seattle. But in all of those situations, particularly the 11th and the 9th Circuit, there wasn't a lot of facts surrounding the situation. In fact, the 11th Circuit in the City of Seattle said they arrested a gentleman under a wiretapping statute because he was secretly recording people in public. They noted in passing that there might be an established right to record police officers. Now, this court said in its decision in Ashcroft v. Kidd that existing precedent must place the constitutional question beyond debate, and that certainly is not the case here. There was reasonable authority that Officer Lochte could have relied on, and
what do you think is the closest case on the facts that Officer Lochte could have relied upon that was at least from a circuit court?
Certainly in Kelly versus Borough of Carlisle, when there was...
Is that the car stop?
Yes, it is, Your Honor.
This is a public park. I can see if you're in a car stop, officer danger is a big deal. And we don't know what the people in the car have. We've got to be very careful. This is a public park. You've chosen to put an undercover officer there for days or weeks. What's the urgency here for safety similar to the Kelly case?
Well, Your Honor, that's an excellent point because, like a car stop, it's unpredictable. You don't know what's coming at you in a car. And similarly, in a protest where there's large groups of people, it's unpredictable what might happen. And in Kelly versus Borough of Carlisle, the officer relied on the city's wiretapping statute, which is exactly what happened here. Anytime there is any authority that may lend its support to the officer's action, the tie must go to the officer. Judge's disagreement cannot make an officer personally liable for his actions. So, Your Honors, I ask you today that you find that Officer Lochte acted appropriately when he arrested Mr. Franklin, the probable cause under the city's wiretap statute, and reversed the 14th Circuit. Thank you.
Thank you, Counsel. Mr. Barclay, are you next?
Barclay. I also represent the petitioner, Officer Brian Lochte, and I will explain how Officer Lochte performed a constitutional search for Fourth Amendment purposes and why he is therefore entitled to qualified immunity. Your Honors, the petitioner is entitled to qualified immunity for 3 reasons. 1, Officer Lochte's limited search of the cell phone was justified by exigent circumstances related to public safety. 2, Officer Lochte performed a valid search incident to arrest under this court's precedent in United States v. Robinson. And 3, even if this court recognizes a novel right that prevents the searches of cell phones incident to arrest, Officer Lochte is entitled to qualified immunity because he acted in accordance with the majority of the precedent available at the time. To the first reason, exigent circumstances related to public safety justified the narrow search at issue.
Well, counsel, how can it be exigent when the cell phone is in the officer's hand and not with the person anymore? What can be happening? He can't telepathically do it or anything like that, right?
Well, Your Honor, there was also the possibility in these specific circumstances that the video had already been posted. And
Then the circumstances are gone, right? The necessity's gone. It's already out there.
well, Your Honor, if the video had already been posted, then the officer would have liked to know that that information had already been made public, and that was connected to the undercover officer's specific safety concerns.
Why is that an exigent circumstance that he'd like to know whether it's
Similar to your question to my co-counsel, that information is important because the police need to know whether they need to remove the undercover officer at that point.
Why not just remove it? Doesn't that would eliminate the exigent circumstance? Your co-counsel, when I asked that question first, said, well, we can still make a reasonable time, place, and manner restriction on the First Amendment. Now we're off the First Amendment. Why can't we get rid of the exigent circumstance by escorting the undercover officer out of the park, never to return?
Your Honor, well, it's admittedly a less direct form of danger to the undercover officer, and there was also the danger to the undercover officer. The safety of the public at large was also an issue in this case. Officers, in this particular situation, the officer was undercover. He had admittedly been deceptive, and he was surrounded by a crowd. The information contained in the video getting out could have caused incidents similar to what had already happened in other cities under this same umbrella.
What's in our record that would support that?
Well, Your Honor, as my co-counsel mentioned, the protest in this case has grown increasingly violent over recent days. Similar protests had already turned violent in other cities. There was a high likelihood of violence, according to an officer with 15 years of experience.
Had this protest become violent? I thought I understood from the record there had been no arrest up to this point for this particular protest.
That's correct, Your Honor. This protest had not been violent to this point. But
one of the leaders is a police officer. Hopefully that doesn't happen, right?
Yes, Your Honor. And even if this court doesn't find there were exigent circumstances in this particular situation, Officer Lochte performed a valid search incident to arrest of the cell phone contents.
Can we get back to the exigent circumstance just a second, just so you finish that?
Sure.
You said it's exigent not only for the officer, we talked about you could have just taken him away, but then you said we had this danger to the public, which started your narrative of all these protests that went violent elsewhere. Before anything can be dangerous to the public, you've got to upload it, which you don't know if that's happening. Then people have to download it, right?
Yes, Your Honor.
And then they have to figure out in the video, is this guy an undercover officer? And then they have to have at least a couple seconds to get mad about that.
Yes, Your Honor.
Right now, they've done all that. What's the danger to the public? You've already escorted this officer away.
Your Honor, those steps can be accomplished on modern cell phones and modern smartphone devices in a matter of seconds. And the download time would be nearly instantaneous. And additionally, the police officers, Officer Lochte didn't know the exact content of the video when he performed the search. And so, not knowing before the search, he didn't know precisely what the video said, but he knew it wasn't good. And that's when the exigent circumstances justified his search of the cell phone.
Go ahead with your explanation of why, even if there are no exigent circumstances, you still win.
Your Honor, Officer Lockday performed a valid search incident to arrest under this court's precedent in United States v. Robinson.
I thought Robinson said that we're talking about containers. Is that the word the court uses all the time?
Yes, Your Honor.
And container is something that has a few things in it, like we normally carry around. And boy, cell phones, these my kids' cell phones, got everything in the world in it. I don't think in Robinson we're talking about something that's got everything in the world in it. Just a few limited items.
Yes, Your Honor. There is admittedly a tension between the origins of this search amendment doctrine and its origins in the United States v. Robinson specifically, and the modern implementation of this search incident to arrest doctrine. Admittedly, physical contents are different than cell phone contents or different than electronic contents. However, several lower circuit courts have specifically held that cell phone contents can be searched incident to arrest.
For example, and there was an Ohio Supreme Court case, Smith, that the 14th Circuit cited in our case.
Yes, Your Honor.
And they talked about how cell phones weren't laptops back in 2009. Well, Robinson's a 1973 case. For heaven's sakes, we were using manual typewriters then.
Yes, Your Honor.
We want to take the word container from that era and say it now includes a computer that is thousands of times more powerful than the IBM personal computer when it came out in 1981 and revolutionized American society. I don't understand how we can put these things together and pretend they're even related.
Your Honor, and this goes to the underlying Fourth Amendment issue, but it also goes to the issue of qualified immunity. Several courts have already held that cell phones can be searched incident to arrest. And precisely that cell phones fall under this court's precedent in United States v. Robinson.
It takes time for older judges like us to get new technology under our belt. We
Yes, sir.
use typewriters.
Well, more importantly, counsel, what about the very cases that say, like for instance, in child pornography cases, that whenever the officer first sees a child pornography item on here, and they got the cell phone from someone, that then they've got to go get a search warrant at that point because they've got the thing, the cell phone, and they got time, so they got to get a warrant at that time. Why shouldn't that logic apply?
Your Honor, for purposes of qualified immunity, the emphasis is on what precedent exists at the time and how close that precedent is to the situation at hand. In Officer Lockley's mind, when he performed the search incident to arrest of the cell phone, he had several circuit court opinions that he could have relied on. While there may be cases, and I'm sure there are, Judge, that require a search warrant before the search of the cell phone, there's also these specific cases, and it would be more reasonable for Officer Lockley to rely on these specific cases. And I point the court to what this court found specifically in United States v. Robinson, and that is, it created a bright line rule that allowed the search of the person and any containers found on the person without an additional showing of the need to protect evidence or the need to protect officer safety.
In Robinson, we were talking about a package of cigarettes, right?
Yes, Your Honor.
So that's quite a bit different. Did Arizona v. Gant change our analysis from what we earlier used in Robinson?
I don't believe it did, Your Honor. While Arizona v. Gant sort of admittedly somewhat returned the precedent back to its roots in Schimmel v. California in United States v. Robinson, it certainly didn't apply that rationale into the cell phone context. And really, if we turn to the issue before the court...
Well, before you leave Gant, though, the law professors think it did, by the way. So you need the law professors think Gant's a big deal. So let's look at it more carefully, because it says that reasonably that the vehicle, here the cell phone, has evidence of the arresting offense. Is one exception, but the first exception is it within reaching distance of the passenger. And here the cell phone is not within reaching distance at the time you're looking at it, right?
I believe the cell phone is within reaching distance.
No. The officer's got it. Right?
Yes,
Before
Your
you
Honor.
start searching, the officer's got it And Lochte doesn't. I'm sorry, Franklin doesn't.
Yes, Your Honor. However, if we look at this court's decision in United States v. Robinson, I believe the suspect was handcuffed at the time. And additionally, in United States v. Chimel, I think the suspect was also handcuffed in that case.
And handcuffed in Gantt.
Yeah, yes.
And in the squad car, right?
Yes, Your Honor. However, if this court, and I think this goes to your point, Your Honor, if this court chooses to recognize a novel distinction for cell phone for Fourth Amendment purposes, it can do so, but it doesn't mean that Officer Lochte is not entitled to qualified immunity. Qualified immunity...
Novel exception for cell phone. What I believe Judge Benton's suggestion is that under Gantt, and Judge Bruns, under Gantt, if the person can't get to it anymore, then these earlier cases that allow you to search it, incident to arrest, no longer cover you once it's completely out of their reach and out of any ability to do harm.
Yes, Your Honor.
And that's not a novel reading, that's in 2009, which is in advance of your situation.
Your Honor, I would point the court to the specific rationale in the United States v. Robinson, where it said that it is per se reasonable under the Fourth Amendment that there is no warrant requirement if it's found on the person or a container, or it's within a container found on the person.
Do you find the Belton case to be consistent with Robinson?
Yes, Your Honor.
Would you agree with me that Belton is no longer good law?
Yes, I would, Your Honor.
So why am I going to say that Gantt doesn't affect Robinson?
Well, for purposes of qualified immunity, the lower courts hadn't clearly established this right. If indeed Gantt...
The court had announced Gantt in 2009, and this occurs in 2010 or 11.
Yes, Your Honor. But if we look at the doctrine of qualified immunity, it requires that the contours of a right must be sufficiently clear that every reasonable officer would have understood what he is doing violates that right. Here, Officer Lochte could have potentially relied on the exigent circumstances doctrine and definitely relied on the search incident to arrest doctrine if he looked at the lower court's holdings.
What's the best holding for your side that's post-Gantt? Gantt in 2004.
People v. DS, Your Honor. And that's the California Supreme Court, where it held specifically that Robinson is applicable to cell phone searches, incident to arrest. If we look at the underlying rationale behind qualified immunity, it says that if judges can disagree on a constitutional question, it would be unfair to subject police officers to personal liability for picking the losing side.
Counsel doesn't say reasonable judges? Reasonable jurors?
I believe it does, Your Honor.
But I know that you've learned from your law professors that those two are synonymous.
I would point the court to the fact, and my co-counsel also did that, is that judges have already disagreed relying the underlying Fourth Amendment violation. In the lower court, in the district court's holding, they did find a Fourth Amendment, they did not find a Fourth Amendment violation. And then in the 14th Circuit's holding, they did find a Fourth Amendment violation. This again provides great evidence that what we're dealing with here is a matter that's not clearly established at this time. For these reasons, Officer Lochte is entitled to qualified immunity because he acted in reliance on existing law when he attempted to keep the city of New London safe. Thank you.
Mr. Piercy. It is Piercy and not Piercy?
It is Piercy.
Piercy. I know, but guess what? Thank you for correcting me. Proceed.
Chief Justice, Your Honors, may it please the Court. My co-counsel, Aubrey Wilson, and I, Adrien Piercy, will be representing Respondent Michael Franklin. In our time before the Court, we will argue that under the circumstances, both First and Fourth Amendment rights were present, and petitioner violated those rights. Furthermore, the contours of those rights were sufficiently clear at the time of petitioner's actions. Therefore, petitioner is not entitled to qualified immunity as to any claims before this Court. I will be arguing the First Amendment issue, followed by Ms. Wilson's presentation of the arguments for the Fourth Amendment issue. We respectfully request that this Court find in favor of Respondent Michael Franklin as to the First Amendment issue for the following reasons. 1. Michael Franklin had a First Amendment right to openly and peaceably audio-video record the officer conduct. 2. Petitioner unconstitutionally deprived Michael Franklin of that right. And 3. Petitioner should be denied qualified immunity as the contours of this right were sufficiently clear at the time of petitioner's actions such that any reasonable officer would have understood that those actions violated Michael Franklin's First Amendment rights. Michael Franklin had a First Amendment right to openly and peaceably audio-video record the officer conduct.
Counsel, what do you do with the Colton case? I know, again, it's an older case, to be sure, but it clearly says that where an individual pesters an officer trying to make an arrest, that they have no First Amendment rights to do anything.
Yes, Your Honor. To answer your question, respondent was certainly not interfering with the officer conduct in this case. Furthermore, this court later overruled that case in City of Houston v. Hill and stated that police officers may be subjected to this type of audio-video recording as police matters of conduct are, police conduct is a matter of public interest. That was just...
Do you think all of Colton is overruled? That's an honest question, though. Do you think all of Colton is overruled?
Yes, Your Honor.
Okay. Thank you.
As was the case here, respondent was simply openly and peaceably exercising his First Amendment rights. This court has found that police officer conduct is a matter of public interest, and the right to audio-video record that conduct is a First Amendment interest in protecting the right to freely and openly discuss government affairs.
What's the case you rely upon the rules?
City of Houston v. Hill, I believe, Your Honor.
Okay. What's the factual circumstances? Help us a little bit.
Yes, Your Honor. In that case, they were discussing a statute which would prevent the people from audio-video recording officer conduct. That case specifically stated that...
What were the facts in terms of what type of situation was being recorded in that case?
I'm not sure that I can specifically tell you the factual circumstances of that case. However, the court stated that it may require police officers to endure significant burdens as there is protection for a citizen exercising his First Amendment rights by videotaping police officer conduct.
Was it a 1983 action?
No, Your Honor, it was a 1987 action.
Okay.
Counsel, at some point it seems that even if there's the First Amendment right to videotape the police officer's actions, that it could move into the area of obstruction. Where would we draw that line?
Well, as stated in the record, Your Honor, respondent was simply recording from a distance. There was no direct interference here with the officer conduct whatsoever. I'm not certain where this court would draw that line. However, I would say that respondent was far removed from that line.
Where do you think we should draw them?
Your Honor, I would say where there is a direct interference with officer conduct such that it is hindering the actions at that specific moment would be an appropriate place to conclude that there was an interference.
What if it jeopardizes the officer, say, within the next 30 minutes? The officer's life within the next 30 minutes. How about that?
Your officer, that would not be the type of situation that I would consider to be an interference with officer conduct, as this court has determined to be an inherently dangerous situation in other cases, such as that of a traffic stop. In those situations, there's an immediate danger presented, and that was not the case here. I think the type of interference that we're concerned with is one that may pose danger to officers.
Well, couldn't a videotape of an undercover officer place that officer in danger?
Yes, Your Honor, it could. However, the 10th and 11th Circuit have both addressed cases concerning undercover officers. In the 10th Circuit, Alvarado v. KOV-TV stated that undercover officer conduct is in fact a matter of public interest, and they refused to reject the right to audio-video record undercover officers.
So is that a freedom of the press case?
No, Your Honor. No, No, Your Honor, it is not. It is distinguishable in that it is a tort case. However, the court stated that it
was
was...
the basic right at issue, not the general First Amendment right, right to free speech, but right to free press.
I'm sorry, Your Honor, can you please repeat?
Sure. They're separate in the First Amendment. Freedom of press is different from freedom of speech. And in the case you're talking about, wasn't the right at issue freedom of press, not freedom of speech generally?
Yes, it was a freedom of the press. However, this court has stated that the rights of the press and the rights of individuals are coexistent. The court further went on to state in that case...
Well, now tell me where we made that crystal clear and that exactly precise.
Yes.
And you mean coexistent or coextensive?
I mean coextensive, excuse me, Your Honor.
Okay.
What's your best view?
That would be Hushins v. KQED in 1978 by this court, in which they stated this court has established that a private citizen's First Amendment right to gather news is coextensive with that of the press. In Alvarado v. KOB-TV, the court further went on to state that conduct of police officers as well as their qualifications is of great public interest, and this aligns with the court's efforts to promote trust between law enforcement officers and private citizens. Further, in Smith v. City of Cumming, the court stated that there was a right to photograph undercover officers, though it may ultimately result in their identity being revealed.
Well, your opponents point to the Kelly case in the Third Circuit and say that's enough to get qualified immunity, just the Kelly case standing alone. How do you address that?
Respectfully, Your Honor, we believe that is incorrect. Kelly, in fact, does not reject the right to audio-video record undercover officers. They simply state that the right to audio-video record undercover officers within a traffic stop was not clearly established at the time of that case. That case was decided in 2009. In fact, it's the only case that...
I thought it was in 2010. Was it 2009?
I'm sorry, I have 2009 written down here.
Okay, maybe right. Somebody wrote down 2010 on my sheet paper. It's not very It can be just a day's difference. Proceed.
Thank you, Your Honor. In Kelly, it was decided in 2009, or possibly a day later, in 2010.
Just tell us why Kelly is not a killer to you.
It's not a killer, Your Honor, because they do not reject the right to audio-video record officers. And furthermore, they state only at that time was the right not clearly established. Further, in the narrow holding, it specifically states that that right was not clearly established within the inherently dangerous context of a traffic stop. This is not an inherently dangerous situation.
How many hundred people in the park would you need before it became inherently dangerous? To out an undercover cop who's been leading a protest for 3 weeks?
Your Honor, we don't believe that the nature of the danger turns on the number of people in the park, but on how attenuated that danger in fact was. This was not a dangerous situation, as it was significantly more attenuated than the traffic stop present in Kelly. Furthermore, we would request that this court would apply a standard of strict scrutiny to petitioner's actions in this case. His actions were in fact content motivated, and as such, those actions are to be considered presumptively invalid until petitioner is able to meet the standard of strict scrutiny.
Isn't that a fact question? I mean, how do we know whether or not what his intent was? He says in his affidavit that his intent was officer safety. So how do we determine that as a court of record and not able to find facts?
As indicated on page 5, Your Honor, of the record, petitioner states that he approached Michael Franklin solely out of concern that if disseminated, the subject matter and Mr. Franklin's opinion of the recording could produce displeasing results. The opposing counsel argues that the rationale of petitioner's action was the content-neutral interest of conversational privacy or police safety. Petitioner states himself, as again seen on page 5 of the record, that he was concerned with a variety of possible results from posting this specific conduct. As defined, Petitioner's actions are content-based, and therefore petitioner must meet a standard of strict scrutiny in order for this to be a valid deprivation of respondent's First Amendment rights.
Now, we've cited several cases that have even been referred to as Kelly, maybe it would kill your case or whatever. At the very least, isn't there a split of authority? And if there's a split of authority, how can it be clearly established?
Your Honor, again, we would argue that this is not a split of authority, simply that at the time that Kelly presented his ruling, the right had not been clearly established. However, that was nearly 3 years ago. Since then, Glick has stated that there is in fact a right to audio-video record officers, and furthermore...
Is Glick in 2011?
Yes, Your Honor.
Okay. So again, we're down to counting days, I guess. Huh?
Yes, Your Honor.
And we couldn't ask an officer to do that, right?
No, Your Honor, we would not ask an officer to count days. However, the First Amendment right has been clearly established. Circuits addressing the matter, though in varying circumstances, including Glick in the First Circuit, Alvarez in the Seventh Circuit, Fordyce in the Ninth Circuit, Alvarado in the Tenth Circuit, Smith in the 11th Circuit, various lower courts, all have come to the same conclusion that audio-video recording matters of public interest, filming or photographing officers, and specifically audio-video recording police officer conduct is in fact a First Amendment right.
Those cases generally weren't very close on facts and things.
That is correct, Your Honor. Some of them were not.
Fordyce, for example, anything close factually there?
No, Your Honor, not factually close there. However, they did say that there was a right to audio-video record matters of public interest. Furthermore...
But they didn't go on to say, no matter what effect it might have on officer safety.
Correct,
Because
Your
that
Honor.
wasn't an issue there.
Correct, Your Honor. However, this
What do you
court...
believe is the closest case?
I'm sorry, Your Honor.
What do you believe is the closest case, factually, to this case?
Glick, absolutely, Your Honor. The facts of that case can be almost identically likened to the facts in this case. Here, respondent was openly recording the officers not in violation of any statute, and the police officer acted in a content-motivated way, deprived plaintiff of that right, and justice found in that case, the court should find here that that right was clearly established. Clear establishment, furthermore, to your point, Judge Leben, states that this court has stated that the facts of a previous case do not need to be materially or fundamentally similar in order for the contours of a right to be made sufficiently clear. Certainly, these cases taken up as a whole have made the contours of this right sufficiently clear, such that a reasonable officer would have been on warning that these actions may incite a violation of Michael Franklin's First Amendment rights. Respondent was simply peaceably and exercising his First Amendment rights. Even if this court finds that this should be reviewed under intermediate scrutiny, respondent still wins, as there was a right, that right was violated. The petitioners offer no substantial government interest as implicated in the facts of this case, and this right was clearly established via a slew of circuit court cases. In fact, they have not even presented a case that would state the contrary, short of the inherently dangerous situations presented in Kelly. For the foregoing reasons, we request that this court find in favor of respondent on his claim of a violation of the First Amendment and deny petitioner qualified immunity. Thank you.
Ms. Wilson.
May it please the court. Aubrey Wilson for the respondent, Michael Franklin. The Fourth Amendment protects against unreasonable searches and seizures. Based on the Fourth Amendment, this court has determined that an arresting officer may conduct a warrantless search of possessions found within the arrestee's area of immediate control only for purposes of officer safety and preventing the destruction of evidence. Without such exigency, any warrantless searches are a violation of the arrestee's clearly established Fourth Amendment rights, and the arresting officer conducting the search loses the protection of qualified immunity. Today, the respondent asks that this court find the petitioner's warrantless search of respondent's cell phone was unreasonable and thus unconstitutional for 3 reasons. 1, the rule that this court applied under U.S. v. Chadwick should govern. 2, under the Chadwick analysis, petitioner's warrantless search of respondent's cell phone was unreasonable. And 3, because petitioner's search of respondent's cell phone violated respondent's clearly established Fourth Amendment rights, petitioner is not entitled to qualified immunity. The rule in U.S. v. Chadwick should govern because Chadwick better applies to the facts of this case. In California v. Chimmel in 1969, this court first narrowed the search incident to arrest doctrine and held that any search incident to lawful arrest may only be conducted subject to exigent circumstances. After Chimmel, this court later developed 2 rules for searches of property incident to arrest. First, when a closed container is found on the arrestee's person, U.S. v. Robinson states that the container may be searched even absent exigent circumstances. Second, when property is found within the arrestee's immediate control, U.S. v. Chadwick states that the property may only be searched subject to exigent circumstances. Here, petitioner's search of respondent's cell phone more closely resembles the search of the footlocker in Chadwick than the search of the cigarette carton in Robinson.
Counsel, are you familiar with the Fifth Circuit's decision in the Finley case?
Yes, Your Honor, I am.
Okay, why isn't that completely against you?
For a few reasons, Your Honor. First of all, in Finley, the respondent's cell phone, or the arrestee's cell phone was found in his pocket. Secondly, the arrestee conceded that his cell phone was a closed container, which respondent does not do here. And third, in Finley, the court ignored the nature and quantity of data that can be stored in a cell phone and erroneously likened it to a pager or a wallet or an address book.
You just think the Finley case was wrong, is what I really hear you say.
Yes, Your Honor.
Okay, but even if it's wrong, is it good enough for qualified immunity to protect the officer?
No, Your Honor, respectfully, it's not. Simply because the facts and law of that case do not apply here. In order to merit qualified immunity, the petitioner must have had a fair warning that the contours of the right have been clearly established, which they were ever since Chimmel in 1969, and again in Chadwick in 1977. That right has thus been clearly established for over 40 years, which any reasonable police officer would have been aware of at this time.
But wouldn't any reasonable police officer be aware of Robinson? And we can't even agree among our circuits whether that's good law. So is Robinson good law?
Yes, Your Honor. Robinson is good law where it applies to closed containers found on the arrestee's person during a pat-down.
And why would this not be a closed container? Would it be any different than if I was a drug dealer and I took down the name and address and phone number of my supplier and stick it in my cigarette pack, and the police officer arrests me for sale of drugs, searches me, pulls out that information? Wouldn't that information be the equivalent of information that's contained in a cell phone?
Respectfully, no, Your Honor, not at all.
Why not?
While one slip of paper containing one phone number and a cigarette carton is some sort of contact information, a cell phone contains an enormous quantity of data that far
So if they have a lot of suppliers listed, that's protected, but if they only have one supplier listed, a reasonable police officer can look at that.
No, Your Honor, that's not the case. This court in City of Ontario v. Quan recognized that cell phones have a heightened expectation of privacy because of the nature and quantity of data contained within them. This was reiterated in U.S. v. Park, where the Northern District of California in 2007 stated that a modern cell phone's virtually unlimited capacity for data storage and retrieval far outstrips other items. Modern cell phones like respondents store a wealth of extremely private information, including all of his incoming and outgoing calls, his address books, his calendars, voice and text.
Here, though, they didn't look at anything like that. It seems to me here, if I read the record correctly, and make sure you correct me if I'm wrong, because you guys know it better than we do. This was open. The video was open on the cell phone when the officer looked at it.
Actually, Your Honor, if I may correct you, the record states on page 5 that the officer had to open respondent's cell phone, find the video application, access that video application, and then pull up the video, which is a multi-step process that indicates that something more than just a quick glance at the phone took place. Furthermore, once that cell phone was under the arresting officer's exclusive control, its entire contents were open to his inspection and search. There was nothing restraining him from going through everything else in respondent's phone. And for that reason alone, this constituted an unreasonable search.
Counsel, can you explain, you said there are 2 exceptions under Robinson, including the possibility that evidence will be destroyed, right?
Yes, Your Honor.
Why doesn't that apply here?
Yes, Your Honor.
And I guess part of my question is, we can take into account modern technology, right? That's what you're asking us to do.
Yes.
And you can wipe a cell phone remotely.
Yes, Your
You
Honor.
don't have to have it. So doesn't the officer need to check and see what was on there before the guy says, oops, I'm going to call my buddy and have him hit the wipe button?
Yes, Your Honor. To address that directly, to conduct a remote wipe of a cell phone, respondent would have either had to log onto an online account and initiate the wipe by sending a remote signal to his cell phone, or he would have had to contact his cell phone provider's IT department. Both of these in this situation would have taken much more time and been extraordinarily inconvenient and not at all an immediate means of quickly wiping away the data before the officer could have reasonably obtained a search warrant for the cell phone. Secondly, even if the wipe was somehow conducted, mobile phone forensics is a subfield of forensics dedicated to cellular data retrieval and extraction even after it's been wirelessly wiped. Therefore, there was no real risk of the data being erased or destroyed from the respondent's cell phone once petitioner had it under his exclusive control. Furthermore, there was no safety risk to the arresting officer, petitioner, to the undercover officer, or to anyone else in the area as a result of respondent's cell phone. Respondent's cell phone simply cannot be likened to a gun or a knife or any other type of device that can cause immediate, imminent harm to the arresting officer and others nearby. The circumstances, as my co-counsel mentioned, are too attenuated between the posting in the video and any risk of violence.
Do we have any idea how many people there were in the park?
I'm not sure, Your Honor. I think something around 100 or so.
Okay, we can at least assume dozens.
Yes.
Can we assume that if they learned this person had been leading the protest over the last 3 weeks was actually a cop, they'd be pretty disappointed with that?
Yes, Your Honor. They might be disappointed. However, to say that disappointment would escalate to mass riots and violence of such a scale that the numerous uniformed officers surrounding the undercover officer could not have acted to protect him or to, for that matter, de-escalate any ensuing violence is rather a stretch. In order for the violence to have occurred, all the protesters would have needed to check the message boards, locate the newly posted video, click on the video, watch the video, and come to the same conclusion based on the respondent's rather ambiguous message that he appended to the video, and then become angry enough to start riots that uniformed officers could not have controlled.
Wait a second. We don't know. The officer, when he looked at the video, didn't know what the ambiguous message was at the end of it, right?
That's true, Your Honor.
So don't we have to look at it from the standpoint of the officer and the safety risk he was concerned about, which was that the video might have explicitly said, officer, undercover, traitor, whatever. And we have to take that as a possibility, not what the real facts turned out to be.
Respectfully, no, Your Honor. Just because it's a possibility does not justify the curtailment of respondent's Fourth Amendment rights. Furthermore, the undercover officer was speaking to a uniformed officer who could have acted to protect him immediately had something arisen. Additionally, even if respondent had posted something that was more explicit, it would have been much more beneficial to the undercover officer if instead of taking the time to seize and search respondent's cell phone, the officer Lochte had instead just removed respondent from the scene or removed the undercover officer from the scene or taken additional measures to de-escalate the situation.
But you would agree that we are to look at the facts as a reasonable officer at the time of the arrest?
Respectfully, no, Your Honor. This is an objective test of what any reasonable officer would have done in this situation, and that is outlined in Anderson v. Creighton. The question is not this officer's subjective beliefs in this circumstance. It's what any reasonable officer who was well-trained...
What a reasonable officer would do under similar circumstances.
I'm sorry, could you repeat?
What a reasonable officer, law enforcement officer, would do under similar circumstances.
What a reasonable law enforcement officer could have done under similar circumstances was immediately act to remove the undercover officer.
Because it's not the role of a court to second-guess officers in the field.
That's true, Your Honor. The court is not well disposed to making those kind of ad hoc determinations. However, the police officer's actions were unreasonable, and he had a clear understanding that those actions were unreasonable, or at least he should have, based on the existing precedent, which had been established for well over 40 years in both Chimmel and Chadwick. This existing precedent would have given any reasonable, well-trained officer ample fair warning, ample notice that the contours of respondents' Fourth Amendment rights were clearly established at the time of the violation. And for that reason alone, petitioner is not entitled to qualified immunity. To go back a bit to the cell phone itself, the reason that the Chadwick analysis so compellingly applies here is for two reasons. First, factually, the facts of Chadwick much closely mirror the situation at hand from the facts in Robinson. In Chadwick, the footlocker was not on the arrestee's person. It was not hidden in his clothing or in his pockets. It was within his immediate control. It was not found subsequent to a pat-down by the arresting officer like it was in Robinson. Here, similarly, there was no pat-down by petitioner. It was not in respondent's clothing or his pockets. And furthermore, like in Chadwick, petitioner had seen the cell phone from a distance and developed reasonable suspicion surrounding the cell phone that led to the arrest. This is part of the reason why Chadwick should apply. Furthermore, Chadwick should also apply because a cell phone, like respondent's, more closely resembles a footlocker than a crumpled-up cigarette carton does.
Well, isn't the key to Chadwick the phrase whether the search is remote in time and place from the arrest?
Yes.
And here, what happened to cell phone is not remote in time and place. It's at the place and at the time.
Yes, Your Honor.
So Chadwick doesn't look to be controlled at all.
Well, Your Honor, if I may, Chadwick does include that in its holding. In the facts of Chadwick, the search of the cell phone the search of the footlocker was remote in time and place, and that was part of the reason why the court found that the search was unreasonable. However, the Chadwick court also made sure to include the clearly defined rule that absent exigent circumstances, searches of property within an arrestee's immediate control are unreasonable.
Isn't it unfair to compare footlockers or cigarette packages to cell phones? I mean, just yesterday we had an example of perhaps a cell phone could be used to detonate a bomb. Can a cell phone inherently be something dangerous that an officer needs to take into custody and search?
Your Honor, you're right, first of all, that Chadwick and Robinson are both maybe not the best analogies. A footlocker and a cigarette carton are different from cell phones. However, if we're looking to analogize to some sort of precedent, we have to look to these two cases since they are the foundation of the search incident to arrest doctrine exceptions. For that reason, once again, a footlocker, because of its storage capacity being 200 pounds, more closely resembles a cell phone, which can store 64 gigabytes of information, equaling approximately 4 million pages of Microsoft Word documents, something much more easily containable in a footlocker than a cigarette carton by any stretch of the imagination. Secondly, while you mentioned the attacks in Boston yesterday, in a situation where a cell phone is actually wired to detonate a bomb, then yes, it may be a weapon. However, that was not the case here. Here it was not the cell phone detonating a bomb, it was the cell phone uploading a video to a message board designed to facilitate discussion pertaining to these protests.
So, counsel, if you decided that it wasn't going to detonate the crowd, then we'd have a different case.
Respectfully, no, Your Honor.
Are you sure? You just told us that it detonates a bomb, and it detonates the crowd.
Once again, I will return to my previous argument, which is that the circumstances between the upload of the video and any risk of violence were so attenuated that it really cannot be compared to the detonation of a bomb. Because of the officers in the area, there was really no risk of safety to anybody. The protesters had been peaceful, non-violent. There had been no arrests, no indication of violence whatsoever. So therefore, under the Chadwick analysis, there are no exigent circumstances here that would have justified petitioner's warrantless search of respondent's cell phone. And because respondent's Fourth Amendment rights were so clearly established, first by Chimmel in 1969 and again by Chadwick in 1977, respondent, or petitioner, as would have any reasonable police officer, was well aware that his actions were violating respondent's clearly established Fourth Amendment rights. And for the foregoing reasons, respondent asks that this court find that petitioner's warrantless search of respondent's cell phone was unreasonable and that petitioner is not entitled to qualified immunity.
Thank you. Barclay, you have 2 minutes for rebuttal.
May I proceed? In rebuttal, I'd like to remind the court that the issue before it today is qualified immunity, or whether Officer Lockett is entitled to qualified immunity. And qualified immunity requires that officers be put on notice that what they're doing violates a right before they can be held personally liable for that violation. Respectfully, what the respondent attempted to do is construct new, previously unrecognized constitutional distinctions and then hold Officer Lockett liable for not seeing these distinctions coming. Regarding specifically the Fourth Amendment, respondent relied heavily on this quantity of data analysis. While that may be a legitimate distinction between Chadwick and Robinson or other circumstances, it certainly isn't something that courts have unanimously or come to a near consensus on is an important distinction. And for qualified immunity purposes, that must have occurred. Also, the respondent said that her position is revolves around this court taking into account modern technology. That is precisely, while it may be appropriate for this court to take into account modern technology, it wouldn't be fair to hold the officer personally liable and to have to make these new distinctions on the fly while he's protecting the city of New London. And that is what qualifies.
Officers in 2011 didn't understand how cell phones work, that they contain tons of data.
The officer almost certainly knew how cell phone worked in this.
Okay, and he knew how to get a video off of a cell phone. He knew how to upload it to a cell phone. So why wouldn't we consider that he can understand how these limitations in the case law should operate if, as they say, it's really attenuated before you get the upload and have any danger anymore?
Well, Your Honor, for purposes of qualified immunity, excuse me, I see my time's ended. Could I finish
You can
this?
certainly address the questions of the justices.
Your Honor, for purposes of qualified immunity, there was more direct precedent which Officer Lockheed could have relied on in this case. And for that reason, he is entitled to qualified immunity. Thank you.
Thank you. Very well argued, counsel. The case is submitted. This court will now take a brief recess.
All rise. This honorable court is now in recess. All rise. This honorable court is again in session.
Everyone may be seated. Well, we've already disclosed the winning team and speaker to the appropriate authorities over here. But as I understand, Dean, we should make some comments at this time.
Yes, please.
Okay. And then we discussed that I will go first. I'll try to get out of it. It's about a new person, so I will go first. All of us thought that you were far above average, and definitely above the counsel that we normally have. Oh yes, in terms of your preparation and your knowledge and all that. I would say 2 or 3 very quick points to you. One point that I would say is, don't be afraid to hesitate a moment after hearing the question. Don't feel like you have to immediately talk, especially while we're asking the question. But even after we end the question, take a second and think about it. Don't feel like, oh no, if I took a second, I've messed up. Take a second and salute the question. Think about what you're going to say, and then respond. Also, you all did a good job of getting your most important points first and giving us a roadmap so that we didn't immediately get you off into some swamp some other place and you never even had a chance to state your basic reasons. I thought all 4 of you did an excellent job.
Agree. I was, compared to some prior arguments I've seen, I thought everybody in this one had a very nice pace. We often get people who get overexcited and really are rushed, and it's hard for either us or you to follow what's going on. And frankly, in these moot court competitions, it's even harder for us to follow what's going on because this isn't a real case to us. We're just here to perform momentarily. We only understand as much as we have to figure a few questions out. So when you go really super fast, you lose us. I thought that was very good. The fluency in responding to questions was excellent. There were a couple times where, we may have, the question Mr. Barclay got about child porn and waiting for the warrant in those cases, I think that was one that maybe was out of some field other than one you were, which is also what we tend to do. I don't blame you for having a short moment where that one took a while. But generally, everything was really shipshape, and for those of you who saw any of our arguments earlier today,
At least you showed up.
We won't name the county attorney who failed to appear.
Well, and speaking of, you probably did not prepare questions about the Boston Marathon. But, to me, the most important thing in moot court, and makes it real, is your responses to questions. And not whether they're correct responses or not, but your ability to go through that, not just your outline, but through your mind, remember that case, go, oh no, okay, how do I explain that? I thought all of you did an excellent job of recalling the cases, both the good, the bad, and the ugly, and trying to respond directly to the questions. And to me, that's the best skill that you can have. You've already got that skill, which gives you a real leg up on the practicing bar already. And as Judge Benton said, it seems like, sometimes don't revert back to high school debate. Remember not to do that. Just take, and Judge Leben pointed out, most of the time you did do that, just take a breath, good pace, think about it, answer the question. I thought everybody did an excellent job, and you probably want to know the results.
We thought it was very close. As you know, we discussed it, and after discussion, I will announce the winning team as the respondents. Back to you at this point.
Yes, thank you, sir. On behalf of all my colleagues at the KU Law School, I want to congratulate all of you on an excellent job. I want to welcome the family and friends of the finalists who are with us this afternoon. Thank you for joining us. I want to thank our judges, Judge David Bruns from the Kansas Court of Appeals, Judge Duane Benton from the 8th Circuit Court of Appeals, and Judge Steve Leben, who is an adjunct professor of legislation at KU Law School, and also on the Kansas Court of Appeals. Thank you all. Let's give them a big round of applause. I've used today's events not just as a competition, but also as a recognition of the basic skills of being a lawyer: legal writing, legal analysis, and oral advocacy. In just 2 short years, these finalists have developed a set of skills that rival those of attorneys who have been in practice for decades. The innate ability of these students may have been there all along, but it took expert training to develop the skills. And for that, I want to recognize Professor Pam Keller and her lawyering colleagues, and thank them for the outstanding job that they do turning our students from great students into great lawyers. So a big round of applause. Representatives from the Folston and Siefken law firm. Folston and Siefken is one of the preeminent law firms in the state and in the region. Members of the firm are loyal supporters to the University of Kansas. The Moot Court program is not the only activity that they help support within the law school. They generously fund scholarships for our students, and they play an important role in terms of our diversity initiatives. With us today are 3 representatives of the firm: Von Burkholder, Jeremy Graber, and Jeff Hurt. And I invite Mr. Burkholder to say a few words on that.
Thank you, Dean, and if it please your honor. Always have to respect the judges, whether they're actually sitting in judgment of your case at that moment. Just very briefly, on behalf of Jeff Hurt and Jeremy Graber, who's the only KU graduate of the 3 of us here today, I want the participants for your hard work here today. I was impressed by each and every one of you, very much so. I would tremble if I had to argue in front of a panel like this in front of any one of you, because you're obviously excellent advocates. On behalf of Folston Siefken, I do want to thank the law school for allowing us to present the George C. Siefken and Robert C. Folston and George Siefken Awards. Both of those gentlemen were deceased by the time I joined the law firm, but both of their sons were old lions of the firm at the time that I joined, and they were also noted for their appellate advocacy abilities and their legal writing abilities. And we hope that continues to be a hallmark of all the lawyers of our firm. One thing I wanted to underscore, which was mentioned by one of the judges and has been touched upon, is in addition to the innate skills and abilities that each of these law students has brought here, what's really most important, something that all of us, no matter our level of skill in writing or making an oral argument, is the ability to work hard to prepare to get ready to advocate for your client. That's what really makes the difference. And here today, none of these folks had a real client. But once you have somebody there that's sitting across from your desk, or maybe it's at the end of an email or in a jail cell talking to you, once you have that real client that provides the inspiration, then every single one of us can apply that will to prepare and to do the best possible job that we can on behalf of our clients. And that's what all of you that our budding lawyers are going to experience in just a few years. And that's the one thing each and every one of us can bring to every case or every matter that we handle on behalf of our clients. So again, on behalf of Folston Siefken, thank you very much for allowing us to do this. And each one of you remember that hard work can make the difference for your client, no matter where you graduate your law school class or if you're one of these field books or not. Thank you all very much.
It's now my honor to award the Best Oral Advocate and also the Best Brief Awards. All four of our finalists will receive an award for Best Oral Advocate, so I'm going to go ahead and distribute those to you. One of them also receives the top honor for Best Oral Advocate, and this year is Aubrey Wilson. We also have awards for the first place brief and the second place brief. This year, the first place brief award goes to the petitioners. It doesn't always work out this way. It just so happens that the second place brief goes to the respondent. Our finalists. Congratulations to all of you who are going to be on the Moot Court Council for next year. We wish you all the best of luck in representing the law school in the national competition. Thank you all for joining us.